Good morning. I'm Gary DeWaal, and this is Bridging the Week for December 3rd through 7th, and today is December 10th, 2018. A federal judge said that it is not a violation of federal law for a trading firm and its chief executive officer to be smarter than their counterparties in ruling against the Commodity Futures Trading Commission in an enforcement action alleging manipulation and attempted manipulation. Separately, the National Futures Association proposed amendments to its guidance to members regarding the contents of their information systems security program. The days are rushing to their shortest day of the year in North America, so I can run outside and enjoy the few strands of sunshine left. Let's get started. A U.S. federal court in New York City ruled that the Commodity Futures Trading Commission did not meet its burden of proof in its enforcement action against DRW Investments and Don Wilson, its chief executive officer. The CFTC had charged the defendants with manipulation and attempted manipulation of the IDEX USD 3-month interest rate swap futures contract from January 24th through August 12th, 2011. The court held that the defendants' trading activities were legitimate and were consistent with their view that the futures contract's design was flawed and that the futures instrument was inherently more valuable than a comparable over-the-counter contract. According to the court, quote, "It is not illegal to be smarter than your counterparties in a swap transaction, nor is it improper to understand a financial product better than the people who invented that product." The CFTC initially filed charges against the defendants in 2013. According to the Commission, DRW established a long position in the 3-month contract beginning in August 2010. Afterwards, alleged the CFTC, beginning in December 2010, the defendants placed bids, quote, that DRW knew would never be accepted, end of quote, artificially to influence the settlement prices in their favor during the 15-minute period that most influenced settlement prices on at least 118 trading days in a quote-unquote banging the close type scheme. A 4-day bench trial before the Honorable Richard Sullivan ensued in December 2016. Afterwards, attorneys for the Commission argued during their closing argument that it was the intent of defendants to produce a quote-unquote price distortion through placement of, quote, illegitimate bids during the closing period day after day for 7 straight months, end of quote, that favored defendants' existing positions by prompting favorable settlement prices. Among other things, said the Commission, defendants' bids were illegitimate because they knew there was no market interest on the other side. The court, in a decision by the Honorable Mr. Sullivan, now a judge of the Circuit Court of Appeals for the Second Circuit, rejected the CFTC's arguments that the defendants' conduct constituted manipulation or attempted manipulation. The court said defendants determined that the 3-month contract was more valuable than a corresponding OTC swap contract because the futures instrument did not appropriately account and adjust for the difference in the greater amount of interest on margin that would be collected by a long position holder in a rising interest rate environment as compared to the lower amounts of interest on margin that would be collected by a short position in a declining interest rate environment. In response, observed the court, each day the defendants would place bids during the closing period below and up to their calculation of fair value. The court acknowledged these bids helped increase the value of defendants' open positions in the 3-month contract. However, the court found that defendants' trading was consistent with their quantitative analysis, and they were always interested to attract counterparties and obtain executions. According to the court, the defendants, quote, made bids with an honest desire to transact at those prices, and they fully believe the resulting settlement prices to be reflective of the forces of supply and demand, end of quote. It was not manipulation or attempted manipulation for defendants to take advantage of flawed exchange rules that were public information where their bids reflected their bona fide perception of fair value and were designed to induce liquidity, ruled the court. The 3-month contract was offered on the NASDAQ OMX Futures Exchange during the relevant time and was cleared through the International Derivatives Clearinghouse. The 3-month contracts were delisted by NFX on December 16, 2011 for failing to attract liquidity. This was a very decisive decision. The National Futures Association proposed amendments to its 2016 guidance that requires all members to implement a written information system security program to address unauthorized access or attacks on their information technology systems and how they will respond in such situations. The NFA does not mandate the form of any member's ISSP, but provides discretion to design an ISSP appropriate for the member. NFA's proposed amendment will require that members provide training to their employees regarding its ISSP upon hiring at least annually and more frequently, quote, if circumstances warrant, end of quote. Members will be required to identify the topics of training in their ISSP's description of their ongoing education and training related to information security. Additionally, NFA's proposed changes will expressly require members to notify NFA if they experience any cybersecurity-related incident and mandate approval in ISSP by a member's chief executive officer, other senior-level officer with primary oversight for information system security, or other senior official who is a principal of the member and, quote, has authority to supervise the member's execution of its ISSP, end of quote. In its proposed revised guidance, NFA indicated it will publish information on cybersecurity best practices and standard-setting organizations that may be consulted for cybersecurity information in NFA's ISSP frequently asked questions that will be updated from time to time. Currently, such information is included in the NFA's cybersecurity guidance itself. Absent objection by the Commodity Futures Trading Commission, the NFA's proposed amendments should be effective before year end. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website at www.bridgingtheweek.com. Check it out. I'm Gary DeWaal. Have a great week, and until the next edition of Bridging the Week, ciao.